Good afternoon, everybody. This is Ali Jahangiri, the voice of EB-5. I'm very excited to have a special guest with us, Ron Klasko, one of the original guys who you have heard his name before. He's the EB-5 king. He started in 1991, built his firm. He has about 105 people at his firm. The firm's name is Klasko, very appropriate. And we are talking to Ron Klasko. So, Ron, welcome to the Voice of EB-5, which is the #1 EB-5 Investors podcast.
Ali, very happy to be part of this and look forward to our discussion.
So, Ron, let's do a little background about your firm. I know it's a multidisciplinary immigration firm. What does that mean? And, what do you guys do over there?
Yeah, it means we do every type of immigration law involving people coming to the U.S. on investor visas. Of course, we do big part of our practice is EB-5. We also represent multinational companies, startup companies. We represent universities. We represent hospitals. So basically, we do every type of immigration law. And I head up the EB-5 part of the practice, which is a big part of our firm also.
Ron, it's after knowing you for a few years, I know that you're a good organizational structure. You set up the correct structure and you grow things. I know your firm has grown larger over the years, but why is that? Is there a growth in like H-1B business? Is there growth in like family immigration business? What's the growth been in?
Ali, it's been interesting. A lot of times when the corporate part of the practice is maybe leveling off, EB-5 has boom times. Over the last several years, up until about 2022, EB-5 had some down years, and those were really boom years for our corporate and university practice. So for us, I think one of the secrets is we keep adding good new people. We keep adding good new clients. And thank goodness we don't lose clients. So that's a pretty good recipe for success, I think.
So it's kind of been all over the place, right? With corporate, you're saying the growth.
Yeah, we've seen growth. We've grown now to 115 people, and we started at 35. So we've grown quite a bit, and that's really been across the board. EB-5, started out with me. Ended up with about 25 people doing EB-5. But, the biggest part of our practice is still the corporate representing companies. We represent some of the world's largest companies, transferring people and hiring foreign nationals. And we also have, which a lot of firms don't have, a big part of our practice representing universities and hospitals.
Yeah, well, it's a big deal talking to Klasko of Klasko Law, now that you guys are a world name here in immigration. So let's talk about EB-5 a little, Ron. I know you started early in the days of the few regional centers that were there. Tom Rosenfeld always references you saying, oh yeah, Ron did this for me back in, I don't know what year it was. But, what was it? Tell me a little about the history. I think there's a lot of listeners that are part of the EB-5 industry here. What was going on back then in 91?
Well, 91, there were no regional centers. And basically it was just this new program that said, if you invest money in some sort of business in the US, it's going to create 10 jobs, you're going to get a green card. And Ali, I'm pretty entrepreneurial. And what I did, November 29, 1990, the new law passes. In 91, I'm in China and Hong Kong and Singapore and Thailand, and actually working originally with one of the big four accounting firms. And the idea we had is that both the accounting firm and we had lots of contacts in Asia and other places interested in investing in the US. And we also had, and we put together a book of kind of mid-level businesses that were seeking capital. And between the accounting firm's businesses, and at that time I was with one of the big international law firms, we had a book of businesses seeking capital. And we went off to Asia looking for investors who might be interested in investing in these businesses and getting a green card. And that's where it all started.
So let's just, go back 15 to 20 years, puts us at around 2009, 2008. Is that when it started picking up really? Did you see it
Well,
around
2008 was an interesting time, but I would say before that is when it started picking up. My crystal ball works better going forward than it does looking backwards, so I don't remember, exactly what was going on in '04 or '05, but I think it was around those years that I started to see some real promise in EB-5. There was the original EB-5 had a few players who were not not taking this program where it should go. And they put together different investment vehicles with balloon payments at the end that never got paid. And it really was a program that maybe it met the letter of the law, but it certainly didn't meet the spirit of the law. There really was not a lot of job creation going on. It was just a program I was not comfortable or happy with. And I decided, I did not want to be a part of it. After the Immigration Service, I forget when it was, but I guess the late 90s, came out with the 4 precedent decisions, the most well-known of which is matter of Izumi. And there was actually a freeze in the EB-5 program while they were trying to sort things out. Took me a while after that to decide that I think this is a worthwhile and interesting program.
Nice.
But once I did, we've gone through ups and downs as a program. I hope we're now at a boom time, and I think the Reform and Integrity Act, while it has flaws, I think it's on balance a good thing. And I think it does address some of the fraud issues in the program and does give investors more confidence that they're investing in a program that's viable. So we've clearly gone through ups and downs as an EB-5 program, but I think we're in an up period right now.
So when you brought up matter of Izumi, and that let's just fast forward to today. How does matter of Izumi reflect?
Yeah, I don't think it's really so much a matter of Izumi issue, but I've advised many clients on this. And I think, without getting too technical, Ali, if it's done right, I think it's perfectly legal. All right. So there's nothing that prevents you from acquiring some of your EB-5 funds through a loan. The Reform and Integrity Act says, recognizes you can acquire funds through the loan. You do have to prove the lawful source of funds of the lender, unless the lender is a bank. So it depends what this I've seen third-party lenders that are and are not banks. And if they're not banks, we need to do source of funds. But if it's structured properly, it is okay. And it is being used out there by a number of different regional centers and projects.
Okay, so they're using the partial loan, partial cash payment.
Well, no. The money coming into the project is all cash. But the question is, where did the investor get the cash from? And in some cases, the cash is coming from a third-party lender, but it goes as a loan to the investor who invests cash into the project. So,
what do you think about it if there is a personal guarantee on this, and the borrower who's or the whoever it is taking the money forgives that portion of the loan if there's a default? I'm sorry, the lender forgives the loan, the 400K or whatever it is, 200K, or I don't know how big these loans are, because you got to go after the person. So either I've just never heard of it as a lending arm that's open. So if they forgive the loan and there's an affiliation between the bank and the project, is that okay, Ron? If there's some kind of affiliation and that third-party lender says, "Hey, don't worry about that 400 grand we gave you that went to the project."
In my opinion, it is perfectly fine. There's no matter how many ways you want to ask the question, it's perfectly fine to have a bona fide loan going to the investor. Now, if you're saying, well, it's a wink and a nod, and you really never have to pay the money back, then it's not a bona fide loan. The Reform and Integrity Act adds 2 things to the previous law. One is the previous law, when they said loans were okay, never said it had to be bona fide. Well, that means something. I don't know what, but it means something. And secondly, the RIA says for the first time that the loan can't be, I forget the exact language, designed to circumvent the requirements of the law or something. So if you're doing something that sounds like a loan, is not really a loan, and we're going to wink and you never really have to pay it back, then you violated the fact that it's not a bona fide loan, and
It's
it
got
is
to be a real
designed to
loan.
circumvent the
It's got
law.
to be a real loan. It's got to have real teeth.
Yeah.
And
I want, when I'm involved, I like to see actual loan documents with default provisions, with everything you see in a loan, with enforcement provisions, with collateral. That's how I advise my clients.
Thank you for explaining that to me, Ron. I didn't understand what was going on. I've seen some of the documents recently, some emails go back and forth about groups. So another hot topics with Klasko here. What do you think about the recent change in demographic with like rural versus urban in China? Has that 10% or 20% set aside been reached? Has it not been reached? Should a Chinese person invest in urban TEA or should they focus on rural? What do you know about that?
Yeah. So from everything I know, the problem with the urban TEA is two things. Number one is there's far fewer numbers available for urban TEAs than there are for rural TEAs. And number two, there's far more investors and demand on urban projects than there are in rural. So it seems to me that if you invest in an urban TEA, you are much more likely to have a much longer backlog than if you invest in a rural TEA. What's either one, and I divide investors, Ali, into those who are in the U.S. and eligible to file for adjustment of status in the U.S. and those who are not. So right now, if you're in a reserved category, whether it's urban TEA, whether it's rural, whether it's infrastructure, the quota is current. And the reason the quota is current is because nothing's being approved. And if nothing's being approved, none of the numbers are being used. So no matter how many people are filing, it's still current till they start approving some stuff. And if they have 5-year processing times, it may be 5 years where it stays current. That's a very big deal for people who are in the U.S. because it means for a long time, whether they do urban TEA or rural, they will be able to concurrently adjust status and remain in the U.S. And if let's say you're a Chinese person who's on an F1 visa in the U.S., and you're going to have to look at having to get practical training, then get an employer sponsor, then file for an H-1B and go into the H-1B lottery, and the chances of being selected are less than 20%. Well, that's kind of a dead end. And you can get out of that whole dead end and reliance on employer sponsorship and everything else if you file an EB-5 and a concurrent adjustment. Even if it takes a long time for you to get a green card, in the meantime, you're legally in the U.S., you can get an employment document, work anywhere you want. You don't need employer sponsorship. You can get a travel document, travel in and out of the U.S. as much as you want, and live your life. And eventually, even if it's a while down the road, get a green card. If you're an Indian H-1B and you want to get out of EB-2, EB-3 in a 50-year wait, you do an EB-5 in an urban TEA or a rural. It's current. You can file for concurrent adjustment, get an EAD, get a travel document, and all of a sudden you're out of the EB-2 forever wait. So it's a very big deal for people eligible for concurrent adjustment of status. If you're outside of the U.S., then you should have your eyes open to the fact that, especially if you do an urban TEA, that there's probably going to end up, even in the new reserve categories, being a long backlog.
So, Ron, I really compliment people on stuff. You know that I'm usually throwing a couple jabs here and there, having fun. You did a great way explaining this. I mean, this was eloquent. I understand what you're saying. So, as we're on this topic, take me one step deeper. What is that concurrent filing like? I'm on an F1. Do I go to the local office in Los Angeles or Chicago? Where do I go, and how long does that take to get that status over to EB-5? Is that a 6-month wait? Is that after I invest? Can you go a little bit in the details?
Sure. So you don't go anywhere. You or your lawyer file a bunch of papers and send it by courier.
There's a consular processing that used to be overseas. Is that
no? So there's two different things. When we're talking adjustment of status, that's only if you're in the U.S. in a valid non-immigrant status.
Okay.
All right. If you're outside of the U.S., you're still going to do consular processing. If you're in the U.S. in legal status, you can file both the I-526 or the I-526E, the EB-5 petition, and the green card application at the same time, all part of one FedEx package.
So I'm in with an F1. I'm here legally. Can that legally be? What if I'm traveling? Is that a legal way of being here?
Right. So when you're talking about traveler, we call it a B1, B2. It's a visitor's visa. Visitor
if I'm
for
on
business
that,
or visitor for pleasure.
Can I do concurrent with visitor? It would be
right.
B2.
There's as much as I'd love to give you a direct answer to that, I'm going to give you a lawyer's answer, which is the only correct answer. So the answer is maybe. Here's how it works. When you apply for adjustment of status in the U.S. and you're doing it on a B1, B2 visa, it's different if you're an H1B, it's different if you're an E2, it's different if you're an F1, but you're here on a visitor's visa. You have to show that when you entered the U.S., you intended to visit and you did not intend to apply for a green card. Okay. So let's give you a ridiculous example. You come in as a visitor on a B1, B2 visa on Tuesday, and you file for EB-5 on Wednesday. Well, probably you didn't tell the truth when you came into the country, and you said, I was just coming to visit grandma, not stay permanently. All right. Now, the farther it gets away from the day you entered the country, the better your chance of being able to show, well, yeah, when I came in 3 months ago, I really just intended to visit. But then I heard about EB-5 and my friend said he'd lend me some money. And then I changed my mind. If you can show that, then you can do this in the U.S. As a general rule, Ali, we do not like to see our clients doing this less than 90 days after their arrival in the U.S. That gives them a period of time to legitimately show that they changed their mind, because otherwise, if they do it sooner, and the Immigration Service 4 years from now gets to looking at the case, they can say, well, EB-5 is fine, but we think you lied when you came in and said you were just visiting, and you can get denied.
So how long do these B1, B2s last?
So there's two different types. One is people coming on ESTA, which means they're without a visa, and then they can enter for up to 90 days. But if they do that, they can't adjust status in the U.S. You can only adjust status in the U.S. if you come with a B1, B2 visa, and then you're usually admitted for 6 months.
Okay, so 6 months' time is a B1, B2. What's the difference between a B1 and a B2?
B1 is a visitor for business. B2 is a visitor for pleasure. Visiting Disney World is a B2. My company overseas sending me to the U.S. to scout out some business opportunity or to discuss a contract, that's B1.
Okay, so now what if you're European person, do they get a B1, or is that just they get to come?
Europeans don't need a B1 to come to the U.S. They can come on ESTA without a visa, but then they can't change status in the U.S.
Okay, so when you hear about a European having visa-free access to the U.S.,
that's ESTA.
That's ESTA, okay.
Yeah. And that means they don't need a visa to come here. They can come for 90 days without a visa, but they can't do this concurrent adjustment that we're talking about.
Well, that's really unique. So this just happens with folks that have to file a B1 or a B2, countries that have to file a B1 or B2.
Right. Now, some people from Europe, even though they don't need a visa, still have a visa. And then they can do this.
So you got this B1 and B2 situation going. You got H1B, you got the Fs, which are the student visa, and you have the group of Ls, correct? There's the L ones. So there's a lot of options, right, to do this concurrent change.
Yeah. So if you're on an H visa or an L visa, then there's no problem. You can do this the day after you arrive in the U.S.
Okay.
If you're on, we talked about the B1, B2. If you're on a student visa, usually, and you're coming to study, and you really are studying, usually there's not going to be a big problem. It depends very much on what visa you're on, and this is really the kind of thing that you should get individualized advice from your lawyer, and the advice may have to do, we have lots of our clients are on E2 visas. So should they do this concurrent adjustment? Well, it depends. Do you understand that if you do this, you may not be able to travel out of the country for 6 or 9 months? Do you understand that you may not be able to work in the U.S. for several months?
After you adjust,
after you file the paperwork,
the concurrent
Yes.
EB-5, you can't
using
work.
E2 as an example. Actually, anything other than an H visa or an L visa.
Yeah.
If you do concurrent adjustment, you will not be able to travel outside of the U.S. I don't care if it's a family emergency or what it is. You will not be able to travel outside of the U.S. unless and until you get an advance parole travel document.
How long
And
is
the
that
advance parole travel document, in the good old days, it took 2 months. Then it was up to about a year. Now it seems to be 6 to 9 months to get. But if you're doing this, you better understand that you're not going anywhere.
You're like on a B1 or B2, you do concurrent filing, let's say at the 4-month period. From that 4-month, when you do the concurrent filing, you're not going to leave until you have parole, like you said. So you got 6 to 9 months from that period, you file the 526,
Yes.
right?
Yes.
And so is that 526 is filed with the cash as well, correct? You send the money out there and then you file it. You invest first and then you file it.
Yes.
So the moment that file hits, what you're saying is you better call your lawyer and say, hey, I want a parole. I got to go visit my family in Vietnam or whatever. I need a parole document.
Well, the lawyer should be talking to you before you file. We know we're going to file the I-526 for your EB-5. The question is, are we also going to file the I-485 for the green card? If so, it's all going to be part of one big package. And part of the same package will be the travel document application.
Yeah.
And part of the same package will be the work document application.
All together.
All in one FedEx.
Now, Ron, we get a lot of incoming calls and, for everything these days. And I see a lot of that 485. Is that the form you're talking about?
Yeah, that's what we're talking about. Yeah.
But I see a lot of that come through like, oh, hey, I just did my 485. So when they're saying this, that means their lawyer has filed a conditional green card with their 526.
That means the lawyer has filed with the 526 an application for the conditional green card at the same time.
Isn't that what you're always supposed to do, Ron? Isn't that what they always do, though? Isn't that part of the EB-5 process?
No, before the Reform and Integrity Act, you couldn't do this.
Oh.
That's one of the big benefits of the RIA. Before the Reform and Integrity Act, you could do this with EB-1, you could do it with EB-2, you could do it with EB-3, but you couldn't do it with EB-5.
Now I know why these questions are coming in. So the 485
is now very big deal.
526.
Yes.
485 in the 485 is what you call a concurrent. That's the concurrent one.
It's the concurrent adjustment of status application.
Okay, so now you can do it. That's why I see so many questions coming in about 485 and 526. Yeah. So hot topics with Ron Klasko. We should do this once a week, Ron. I'm learning a lot.
How about once a day?
Okay, how about this, Ron? What if I'm here on a Haitian? There's a lot of people from Haiti in Miami, right? So they're here with these strange. I'm not sure what it is, but they're here on these different types of like Ukrainians and Haitians. What is their status? Is that ESTA?
Yeah. I'm the wrong guy to ask about Haitian. If I get a Haitian case, I refer to a lawyer who deals with Haitian cases. There's special procedures for Haitians that don't exist for anyone else. Yeah. And we don't deal with that. Usually a lot of the lawyers in Miami deal with that.
I see. So, okay. So I'm obviously, picking on a nuance. How about Ukrainians that are here? Didn't we allow a bunch of them to come here on?
Yeah. Some of them are here on visas, like the B1, B2s, and then the same rules apply there. Some of them may have been paroled into the U.S., which is a separate basically, the government can bring to the U.S. anyone they want to bring. even if they don't have a visa. And those are called parole programs.
Is there a bunch of those parole programs?
There are a handful that are usually very country specific. And under the law, to do this adjustment of status, you have to be inspected, which means you can't sneak into the country. And you have to be either admitted on a visa or paroled. And so if you're, for example, a Ukrainian who was paroled into the U.S. and you didn't sneak in, you can do this concurrent adjustment.
And paroled is another form of a way to legally have status in the U.S., right?
Yes. It
It's
doesn't
an
apply to
application.
too many people, but the answer is yes.
It's called a parole application. What's it called?
Yes. Yeah. There's programs called humanitarian parole.
Okay.
So, it could be that somebody, we brought to the U.S. because they were escaping a very difficult situation. And there's applications you can make for humanitarian parole. We can do it for entire groups of people.
Like Venezuela. There's 150,000 Venezuelans that came through.
Yeah, most.
They're in New York now. Are they paroled? What's going on?
There's a separate program that we haven't talked about that applies to some of these countries, which is called TPS. Okay, that's temporary protected status. Mm-hmm. And the issue of whether you can do this adjustment of status in TPS is actually a very, very hot issue right now. A lot of us think that is perfectly proper, that if you are on doing an EB-5 and you're on TPS from one of those countries, Guatemala or Honduras, or there's various countries that have TPS, that you should be able to do concurrent adjustment. But that's actually one of the hot issues, not in EB-5, but in immigration law generally.
So TPS, does that mean you're legally there or you're illegally there?
Yeah, you're very legally here.
How do I get TPS? I'm a Guatemalan or a Venezuelan. Yeah. How do I get that?
First of all, it's very country specific, and it has to be renewed periodically. And in each TPS, we say what the rules are. So it could be for one country, we say in order to be eligible for TPS, you have to have been in the U.S. since, I'm picking a date, March 17th, 2017. And that says who's eligible.
Do we have a TPS for Hong Kong? That because Hong Kong was recently...
No, we don't have TPS for Hong Kong, no.
Okay, do we have a TPS for Venezuela?
I believe so, yeah.
Okay, so there's these rules, the TPS rules, that are somewhere. Where are they located? How do I read about TPS?
There's two. It would be in the regulations, and it would also be in the USCIS policy manual.
Okay, so we're really this topic, which is this is my first time I'm doing a topic on the podcast for concurrent in this depth. So we'll definitely make sure our users and our listeners know we're doing this concurrent filing topic. So you got this TPS, you have parole, you have the B1, B2 visitors. Then you have the whole set of employment ones, E1, L, E's, L's. There's another employment one, right? H1B, right? H, L's, and E. Yeah. And then what am I missing one here? Is there another category here other than the ones I mentioned?
From A to V.
Okay.
But most of them don't apply to hardly anyone. There's also the J1, which is an exchange visitor. That's very often going to be doctors. It might be students in some cases. It might be teachers. It might be trainees. There's various categories of J1s. Okay. And when you're dealing with a J1, you have an issue that you have to look at that you don't have to deal with for any other visa. And that is that some people on J1 visas have a requirement to return to their home country for 2 years before they can apply for the I-485 green card. And so we have to figure out if our J1 client has that 2-year return requirement. And if so, in some cases, we can get it waived, forgiven. And then we sometimes will try to do that. So that with J1s, there's other issues.
Requirement, or is it the United States requirement?
It's a U.S. requirement.
So why would they require someone to go back to their country for 2 years?
It goes back to the days of the brain drain. And the concept in the brain drain, now in my mind, the big issue is competing with other countries for the top talent in the world. But if you go back 30 years ago, the big issue is U.S. doesn't want to steal talent from other countries. And we want other countries to know if they send their people to study in the U.S., that we're going to force them to go back because we're not going to steal your talent.
Who's going to change this law for us, Ron? Who's going to go in there and rally and say that that's not the case today? This is archaic.
Ali, I've been at this for a long time, and there's a whole variety of stuff that I remember saying when I first started. Well, by the time I retire, this will change. As I count now my years of experience in decades, I realize that a lot of this stuff ain't changing. The one thing we know about immigration, Ali, is that everyone agrees. Everyone, the most extreme right and the most extreme left, agree on one thing, and that is our immigration system is completely broken. The only problem is everyone's solution is different. And the extreme right has a very different solution than the extreme left and everybody in between. And the one thing they also know is if they legislate on immigration, they will lose votes no matter what they do. And so we go through a situation where decade after decade, we say, God, these immigration laws make no sense, and they don't change. And that, unfortunately, that may be a story we'll be telling 10 years from now.
So a lot of these immigration laws, like these J's, sound like they have an archaic twist to them. We've gone over the major ones.
Yeah, those are the major categories of people coming to the U.S. and doing EB-5. Yeah.
On temporary. We talked about temporary visas converting to
EB-5.
The 485.
Yes.
Okay, so that topic aside, let's go to your frequently asked questions. Like people come to you. First of all, can they hire you, Ron? Are you hireable? Are you what, $2,000 an hour? What's your rate?
My rate is incredibly reasonable for the service I provide.
So you are hireable?
Yes, we do work with new clients every day. So
I figured guys like you and a few other folks I know are non-hireable because you guys are busy managing the firm. So
no, I'm a full-time practicing lawyer. My clients will tell you down to the last one that if they want to talk to me, they talk to me.
That's good. Okay, so first we know you're hireable. You can call Ron and hire him, which that might just be a fun exercise in itself. I might just have fun for a couple hours having Ron be my lawyer. Secondly, they hire you. What is the other hot topic? So they hire you. You're like, what are you hearing out there other than like the stuff I brought up about the loan and then also about all this concurrent stuff?
So I'd say one of the biggest issues right now in EB-5, Ali, is the government processing times and how long is this actually going to take? That's a difficult subject because the government is really way, way, way too slow in processing these cases. We can debate, and I don't know exactly why that is.
Are you also involved on the corporate side, like doing regional center applications?
Oh, by all means, yeah, yes.
Tell me about why it's taking so long for these RC applications to get approved. Is that?
Yeah. So there's a simple reason. When you say an RC application, so there's two main types of regional center applications. One is the I-956, which is the designation for approval as a regional center. And the other is the I-956F, which is for approval of a project for investors to invest in. Now, we don't care about the processing time of the I-956F because investors can invest and file 526s the minute the project application, the I-956F, is filed. So yes. The key there is just getting it filed. And then if it takes a year or 2 years or 3 years, we can still be marketing for investors, having 526s filed.
In that project filing fee is how much on that F?
I think it's $17,795, I believe. It's a very high number.
It went up, right? It went up.
Yeah. Well, it not only did it go up, I believe 17,795 is the right number. And there's a proposed increase. The government is put out a notice in the Federal Register proposing to increase it by think about 300%.
Wow.
Which is nuts. You asked me why the I-956, the regional center application, takes so long. One of the reasons is because every one of the 630 regional centers has to file this I-956F. So there were, I think 630 was the number, who were approved under the old law. And all of those regional centers continue to stay, can continue to stay in business. But the government says you need to file this I-956. We don't have a deadline yet. We don't know exactly when it has to be filed. They originally said by December of 2022, then they extended it. Right now, there's no deadline date. But if all these are going to file, plus if I'm filing for a new regional center, I've got to do this thing. In the old days, when they would get a handful of these things before the new law, it could take them 2 years. Now, if they're getting hundreds, it may take more than a couple of years.
956, the one we're talking about, is the regional center, a new regional center, but we're talking about the E, right?
The I-956 is for designation as an approved regional center.
The I-956.
If you were not a regional center before,
yes,
then you have to get that approved before you can sponsor.
And you're saying
project.
That's in the same line. You're saying that's in the same line as the 956F as well.
No,
those
they're different lines.
The difference is it quicker to get a 956 approved than an F?
Right now, we haven't seen hardly any of either approved, so we don't know exactly.
Wow. Okay, so we barely have seen approvals. How about the expansion of these regional centers? What application is that? What's that called? And is that taking long as well?
What do you mean by an expansion?
Call it, you're in Dallas and the regional center files an expansion of an area.
Geographical expansion, sure.
Yes. What's that called?
The bad news on that is that, as I said, if the pre-existing regional centers can continue to do business even before the I-956 is approved. However, if they want to expand their geography, they can't do that until the I-956 to expand the geography is approved. A regional center that wants to expand has a couple of choices. One is file the I-956, request the expanded area, and wait maybe years for the approval before they can sponsor a project. Or the second option is to buy a regional center that already covers the geographical area. And then if they purchase it, the next day they can sponsor a project. And that's the reason, as I think you know, why there's a big market right now for purchasing regional centers and for selling regional centers.
Because the wait time for the expansion,
right?
You can't file your F unless you expand first,
right?
Okay, so have you heard of any of these expansions getting approved?
Yes, but not many. There's the processing times are slow. Remember, all this stuff we're talking about is new, and you couldn't do this until I forget the date when it was in 2022, but we're not seeing a lot of adjudications yet on these things. It's not like we're seeing a lot of denials. We have seen some approvals, and we have seen the Immigration Service be, I would say, liberal in the geographical areas that they're allowing to be approved. And we are seeing many multi-state regional centers being approved. So yes, we've seen some of them approved. Most of them are still pending.
Doesn't it make more sense, Ron? I know you represent regional centers a lot. I know that's a lot of your business. You're in the business world of this stuff very deeply. So is there a system or a way that you can access these regional centers and the areas you want, or without getting, as a developer, now I'm shifting as a developer, but without getting gouged on the price of a rental, of an affiliation? Is there a way to get access to a regional center without paying large basis points on an affiliation? Do you have a network of people willing to sell these? Do you have a bucket of folks that are willing to reasonably sell these?
Well, I can tell you what I have created, which I think you know. I've created a separate company, which is separate from the law firm. It doesn't provide legal services, called Regional Center Marketplace. www.regionalcentermarketplace.com. And basically what that does is it matches regional centers that are looking to sell the regional center because they're not interested in doing business under the new law for a variety of reasons, matches them with developers that are looking to establish have a regional center, and with regional centers that are looking to expand to new geographical areas and want to purchase. We're kind of a matchmaking business that brings the two together. We also work with projects that are seeking regional center sponsorship. And we are often able to match the project with a regional center sponsor. And there is no, quote, market value that I know for regional center sponsorship. Every regional center, some regional centers don't want to do it, some do. And how what their standards are for what types of projects they would sponsor vary greatly. How hands-on the regional center will be on the project varies greatly. How the regional center charges for its sponsorship varies greatly. That's not something I can say, well, here's the market.
There's no consistency in the market because it's very fragmented, is kind of what you're saying.
I think that's very true. And there's certainly no place I know that you can go that says, well, here's a one-stop shop that you'll get all the regional centers who are available and what they charge. That doesn't exist to my knowledge.
How many active ones are there now, Ron? Well, how many got disqualified and how many do we have left?
I think the number is around 600, but I don't know for sure.
Okay. So
now that's a different issue from how many of them are going to continue to exist. There's some, I would say hundreds of that group that are not going, when the government says you must file this I-956 to continue in business, there may be hundreds of them that say, we're not going to do that because we don't want to do any new projects. But until that happens, all the ones that existed before still exist. And I think that's over 600.
What do you think of the same sense if someone has a project, an old project in a regional center, and they're trying to sell it? Let's just say regional center A has done one project for $20 million 4 years ago, and now says, you know what? We really don't want this. We really don't want to pay the fees. And it's still an active project. They just want to sell their regional center. Do you think there's liability associated with that? Do you think what's your advice on those deals? Is it be careful, don't buy anything with projects in it? Or is it, hey, just get an indemnification on the current project?
Well, first of all, Ali, I don't want to pretend to be something I'm not. I am not a commercial transaction lawyer. I'm not negotiating the deal. I'm not preparing the contract. And you want to have a damn good corporate lawyer doing all of that. But if you're buying a regional center, by God, by all means, there's potential liabilities. And you better look at them very closely. And you better have protection in your contractual documents to deal with that. It's like buying any business, all right? If I'm buying a gas station or I'm, buying a nursing home, there's potential liabilities. So I'm buying a business. A regional center is a business.
So in your marketplace, there's got to be regional centers that have deals, older deals in them. I mean, that's just
sure.
So what do you do?
If I'm matching the seller with the buyer,
yeah.
I am saying you should, make sure you have a contract lawyer who's going to negotiate the deal and look at all these issues. I may be able to help you with some of the immigration issues, but basically this is a contract to purchase a business. You're not going to hire an immigration lawyer to do a contract to purchase a business. That's not my role. I may be able to advise the contract lawyer on the EB-5 issues, but you're buying a business. And like any other business, you better have, cover a lot of bases, including your liabilities and your risks.
Interesting. I always wondered what you do when there's, I don't want to call it a dirty regional center, but assuming a clean one has nothing in it. The opposite of clean is dirty. It has a project in it. What do? Do you advise your clients against it, or do you say, hey, just maybe take the risk, but indemnify yourself of the potential hazards of this?
I mean, there's a lot of potential issues, Ali. If there's fraud, are you going to face investor lawsuits? Are you going to face the government terminating the regional center, and you end up buying something and getting nothing? I mean, yeah, there's a lot of issues that you have to look at.
Well, how could there be fraud if you're the buyer and someone else committed the fraud?
If the fraud existed, if the regional center that you purchase engaged in either acts of commission or omission that results in, it could have been something that happened 4 years ago. And I buy this regional center today, and tomorrow the government says, we're going to give you a notice of intent to terminate the regional center for what was done 4 years ago. The government doesn't care that the ownership changed. They're still going to terminate the regional center. And if I'm the buyer, I better have done very good due diligence on the history of the regional center to make sure, I think they call it a pig in the poke, that I'm buying something that's worth something and it's not going to be terminated tomorrow.
Yeah, that's good to know. Thanks, Ron. I think that's a good lesson for people to hear. We were over by about 15 minutes, but I think it's warranted. You gave some amazing information. Look forward to seeing you, I hope, soon. And if there's something that you want to say out there to anybody, please feel free to say it right now. Before we terminate the podcast, is there anything you have to say to the EB-5 investor group?
I guess what I would say is the EB-5 program can be a very, very good program. You have to be careful in deciding, where you're going to invest. But there are a lot of great regional centers out there that have done a lot of great projects. If you invest in a good project with a good regional center, it can be, really a life-changing situation, because there are so many people who have no other options under U.S. immigration laws for themselves and their kids and their families. And EB-5 is the only option available. And it can result in getting a green card for you and your family. And it becomes a win-win situation. It enables U.S. businesses to expand. It enables buildings to be built that may not otherwise have sufficient capital. It creates jobs, and it creates green card opportunities for people who will come to the U.S. and contribute to America. So for a lot of reasons, I think it's a really good program, as long as people don't screw it up.
Thank you, Ron.
My pleasure.
Wonderful person to talk to, and we'll see you at the next event we have, or overseas. Thanks.
Look forward to it. Take care. Bye.